Evening, everybody. Excuse me. Welcome to the Town of Naples Planning Board meeting for Tuesday, March 18th, 2025. I know our clock's going to ding in a minute, but would you please join us in the Pledge of Allegiance to the flag? I pledge
allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you. Item 2, in attendance tonight, we have Sue Fleck, Martina Witz, myself, Doug Bogdan, Jim Allen, Robert Fogg, Kathy Eddy from the Code Enforcement Office, and Kathy Tombarelli, our Town Municipal Planner. 2A, do any board members have any conflicts of interest with items brought in front of the board this evening?
No.
No?
No.
5-0? 5 noes? We'll move to item 3 is to review the meeting minutes from March 4th meeting, 2025.
I make a motion to accept the minutes as presented.
Motion to accept the minutes as presented by Martina. Have a second?
Second.
Second by Jim. All in favor?
I wasn't here.
Okay, so that's 3. Sue,
You, me, and Jim.
Okay, so that's 3-0.
Yep.
Old business is none, table business is none. We move on to item 6 for new business. Is anybody here tonight to provide input to the item B for the amendments to the Naples for the Naples land use ordinances? Seeing no one from the audience that said yes to that. We're going to switch the order of that. We're going to do 6B first, and we'll move right through that, I hope. So we're going to move on to new business for item 6B, amendments to the Naples Land Use Ordinance, sections 400 definitions, 503 accessory dwelling units, 705 signs, changes to the Budget Committee bylaws, a new Naples solicitation ordinance, and to repeal the minimum lot size ordinance in AMP. Sign ordinance, both of which have been incorporated into new current Naples land ordinance. So we'll take them one at a time. First up I have is the municipal budget ordinance committee. Is there any more input other than what's on the table in front of us from board members?
No, Mr. Chair, the ordinance review committee worked on these ordinances as directed by the select board. The municipal budget committee ordinance apparently had never officially been adopted, and we had different documents, and so this was the most recent that reflected having a 7-member board.
Okay.
So it's kind of almost like a housekeeping type of thing to accept this ordinance.
Okay. Anything else, nobody? Okay. We'll move on to the next one is for land use ordinance amendments to May 2025. And this is the one that question 2, it has to do with accessory dwelling.
Right, so there was a change that needed to happen to the wording that we had around the accessory dwelling unit. We thought we had it correct to reflect the changes in the regulations around LD 2003. But on further review, we had to change some verbiage on there, allowing accessory dwelling units, even if it is on a non-conforming lot. So we had to change that. So that's what that's all about. So that's kind of like not an optional kind of thing. It has to happen for a state statute. That's why that was
in compliance with the state statute.
Yeah.
And it doesn't mean that you can put any accessory dwelling on it. It just means that as long as you don't make it more non-conforming.
Okay, 3's definitions. Do you go over definitions?
Yeah. Good. Out of order here. These yours? Okay, yeah. And definitions, what we did under kennels, we added doggy daycare to our existing definition of kennel and made that a little bit more specific. So when folks get the documents, if they want to get them online or pick them up at the town hall, they'll see that definition's a little more specific. It's going to read any place, building, tract of land, abode, enclosure, or vehicle where 5 or more dogs owned singly or jointly are kept, sold, housed, bred, trained, or boarded, including dog daycare for a fee. Site plan review approval by the planning board is required for this use. So that will be a change of that definition. The other definition is that we realized we never actually had a definition for a butter. A butter was referenced in our ordinance in a few places, indicating that they were somebody that's 500 feet away, but we never actually had it as a standalone definition. So we're adding the definition of a butter, indicating that it's a property sharing a common boundary with or within 500 feet of a given parcel, et cetera. So you'll be able to read that. And then finally, we added a definition for political signs. And when you look at it, it will be sign, comma, political, because all our signs are defined under sign, comma, and then a type of sign. So we're defining it as a temporary sign, political in nature, on public property or within public rights of way, shall be permitted as provided by state law. Political signs are prohibited from all town-owned properties except the rights of way as otherwise provided by state law. I actually have a question about this. Larry Anton, who's on the Ordinance Review Committee, wrote to me the other day and said, wanted to clarify that because we're saying that the political signs are permitted on public rights of way, is Village Lane a public right of way? Because that's a place that we would not want a political sign, I think, right? Because I think everyone regards Village Way as the driveway to the town offices. So,
Yeah, but it's a driveway, it's not a public way.
so that's what I'm asking. So is
Yeah,
Village
it's a
Way?
driveway, not a public way, and it would be within, it would be too close to the town office as well.
That was what my initial
Yeah.
response to him is. I think it would violate the state statute where it says you can't have political signs that close to a polling area.
Polling area, correct.
But that's only while elections are happening, so that's why I'm just bringing
Yeah.
this up. I just want to make sure that Village Way is not considered a public right-of-way.
I don't believe that it is, and if it is, we can clear it up the next round, would be my suggestion, but I don't believe that it is, and they're not allowed, it's too close to the polling place, it's too close to the town office.
Yeah.
They are allowed in the right-of-way out very front.
Yes.
But not here.
Okay. And the other part of, well, I'm in the definition, but the other part of the sign definition is that, so political signs as permitted by state law will be added as an exemption from a sign that needs to get a permit from the code enforcement officer. So
Correct.
that will be added as part of the sign ordinance. What's the next one, Doug?
Okay, the next one is the solicitation ordinance.
Okay, so that's a brand-new ordinance. Everything about this ordinance is new, and it will require permitting from the town office if somebody wants to go out and solicit for either a for-profit or a not-for-profit, and their permit would be good for a year. I guess this was at the request of one of the select board members. This was to address people just soliciting anytime, anywhere. This also limits days. We can't solicit on Sundays. They have to show their badge. That's all part of it. They'll get a ID that they got their permit at the town hall. So that's what that one's all about. It's all brand new. So that's not actually a land use ordinance, so it's a little weird that we're doing the public hearing here at a planning board, but that's a separate standalone ordinance.
Yeah, there were certain groups that were exempt as well from having to come to the town office.
Churches, et
Yeah.
cetera. Yeah.
Right.
Well, it was just for the cost, right?
Yeah,
From the
they're
fee.
exempt, they're exempt from the fee. They're
Fee,
not
from the
exempt
fee,
from needing to get a
From
permit.
actually, exactly.
Right, still have to come to the town.
Yeah, and we don't know what the fee is. The select board sets fees
They'll set the
separately.
fee schedule, correct.
Yeah, so
So how many Girl
everybody
Scouts
has,
have to get a permit to go sell the Girl Scout cookies?
yeah, this is what I brought up multiple
Yeah,
times.
you said the same exact, we had the
That's
same
what I
exact
said.
question. Yeah,
And the response I got was that most Girl Scouts don't go door to door anymore. They'll go set up in front of the umbrella factory or something, and then that's
They're
on
not
private.
aggressive enough, they'll sell more cookies if they go door to
And
door.
then that's on private property, in which case they wouldn't need a permit.
Permit, right.
Because they're allowed,
because
they're
they have
private
permission
property
to be
owner.
on the private property, yeah. This was something that we were directed to do by the select board. we being the ordinance review
Ordinance
committee.
Yeah.
There was some uncomfortable solicitation on the causeway
Yeah.
in the summer.
There's also been some fraud as well, where people are being taken advantage of by unscrupulous solicitors.
Okay? And the next one's for the minimum lot sizes.
Okay, this is just something that has never been redacted from our ordinances, and I just really want, we've been making the point over and over again, we still have minimum lot sizes, it's just completely integrated into our land use ordinance, so we're just removing this as a standalone ordinance, because you'll still see it on our website, and it's confusing, but, so we still have stipulations and standards around minimum lot size, but it's part of our land use ordinance. This standalone is what we're going to be removing.
Yeah, that's from 2002, I think was the last time that it was updated. And all of those minimum lot size standards are in each zoning district in the land use ordinance now.
And then I think there was also redacting, or the standalone sign ordinance, right?
You just said the sign ordinance.
Right, so we have, yeah, so
Just said the
there's
sign-
two
yeah.
things happening with the sign ordinance.
Right,
There's the
so-
political signs, and then there's the removing the old standalone sign ordinance, because it has been incorporated into section 700, I think, of the land
Yes.
Of
use
the land use,
ordinance.
right.
Yes.
So don't panic, we still have a sign ordinance.
All right, didn't go away, there's a lot of work that went into that.
These all should have been done 2 or 3 years ago when
They
we
sh-
changed it.
They should have been done at the same
At the same time.
time. There should have been language saying that this is meaning to supersede all previous ordinances.
It just didn't happen. Cleaning up a lot of it. Okay, any other comments on any of those, no? Okay, so we'll take a recommended motion.
So we're, yeah. So the planning board moves to well, you know, we should only be doing we should just be doing the land use ordinances, right? We don't really recommend for the
I
other
would
ones.
make the recommendation for the land use
Use
ordinances. Yeah.
So we move to recommend that the ordinance language for the land use ordinance as presented to be included on the town warrant.
Right, that goes to the select board, and the select board will put it on the town warrant.
Okay.
Second.
So we have a motion to approve the land use ordinance changes, language changes. So it'll go to the select board, for the select board to place them on the town warrant. Motion by Martina, and second. All in favor? 5-0. Thank you. All set with that? Okay, and then we close that public hearing, and we'll open up the planning board again back to new business. Item 6A is a request by C.N. Brown Company for a site plan review for a new convenience store and fueling station application located at 99 Roosevelt Trail, map lots U06, U07, and U06, I'm sorry, U06-7 and U06-8 in the commercial zone district. Someone from C.N. Brown.
Good evening, everyone. My name
Good afternoon.
is Jason Dennis, and I am an attorney at Hastings Law Office in Freiburg. We are the legal counsel for C.M. Brown in this matter. You wouldn't remember me from the last go-around because Tom Saucier probably did much of the speaking because he knows the technical stuff that I don't know. So I'm not going to talk to you guys about that tonight. I'm going to talk to you about what I view as a couple legal threshold issues that I think I would submit to you that you need to decide before we move forward substantively with the application. And what those are, as we see it, is really what the scope of tonight's review is. The Naples Planning Board previously approved this exact project under this exact same application minus one piece, which was the driveway. It was approved by this board at 42 feet on appeal by Energy North, who I believe is represented here tonight. The Board of Appeal said that though Maine DOT was totally fine with that, the ordinance in the town of Naples has a 40-foot width, and so that there needed to have been an express waiver with regards to that. And even though I raised the idea, but didn't really argue at the Board of Appeal that there was maybe an implicit one, I couldn't really make that argument in good faith and fairness to the Board of Appeal because there just wasn't enough in the record to say that that had been officially waived by this board. So what happened at that meeting, the Board of Appeals meeting, on Energy North's appeal is they reversed this board's decision and remanded it back, essentially with instruction, as I recall from being there and I reviewed the video, to address just that one issue. The Board of Appeal rejected every other argument that Energy North made. And so I would submit to this board that that is the law of the case for this application so far. This board said all these things are fine. The Board of Appeal said all these things are fine except one. And so no decision has been made that has actually overturned any of that stuff. The other technical stuff that Tom Saucier behind me could talk about with regards to sight lines and parking and all those wonderful things that surveys and engineers talk about and us lawyers maybe screw up 50% of the time. So that's one. What is the scope of the meeting and what you are to decide on? Are you going to focus on just the driveway, which is what the Board of Appeal really did say? Within that, I've received today a letter from Archipelago, who represents Energy North, that says this board can't even decide that. So that has to be decided as well. The Board of Appeal sent it back here for that very reason. The distinction to be made, is it a waiver that you can grant, or is it a variance that would need to be granted by the Board of Appeal? The Board of Appeal sent it here to address that, so I would submit that I think they've passed the buck back to the planning board. The other issue is under the driveway ordinance, and I'm just going to pull it up on my phone here. I actually have it up on my phone. The section 3 permit required talks about that coming from the road commissioner upon application. And the road commissioner in the town of Naples is fine with this. So the person who's specifically tasked under the driveway ordinance to deal with these permits for driveways, they, as well as the Maine Department of Transportation, have said it's fine for 42 feet. So this isn't a substantive argument yet, as far as approving this application, but it is, what are we actually going to decide? The second piece that has come up since the Board of Appeals hearing is the issue of the new buffering ordinance. That changed after the original approval of C.M. Brown's application, same application. So there's that question. Does C.M. Brown need a waiver from the new buffering ordinance? My legal opinion is that I present to you and would ask you to entertain a motion, and it may be that we continue for the board to get legal advice, and that's up to the board, of course, to make that decision, is that it does not need to meet that particular new ordinance. It's my understanding that the new buffering standard, when passed, did not have a retroactivity position, meaning applying to applications that have been given substantive review. And in the Board of Appeal meeting, when council was discussing, when council to the town, the board, was discussing what they were going to do when it came time to make the motion to decide whether we were done and we would move on to the shovel phase, or if we had more legal stuff to do, unfortunately. The motion was that it would go back to the planning board, to you all, and I've got the time frame, I don't have the video to play, but I could give it to you for the record, which it was, it's the same application. And so the legal standard under 1 MRSA 302 is that once an act or an ordinance is passed, if it is then later repealed or amended, a application that has been given, well, that it's pending, meaning it's been given review of the application, you do not apply the new ordinance to that. It's got a vested sort of status, if you will. So this is a little bit different in that you got an application, you approved it, same application that's here today, just with a waiver request, exact same project that the Board of Appeals said is fine but for this one thing, and so you are essentially reviewing the exact same application just with one request for an additional waiver. Meaning, as I view it through the law, and obviously you could get 10 different legal opinions on this, I suppose. Really, should only be 3, yes, no, or maybe. But I say yes. And yes, meaning it does not apply due to the fact that it isn't retroactive to an application that has been substantially vetted and approved. So those are the two threshold issues, so that Tom and CM Brown knows essentially what they are officially asking this board to do. I think from a legal matter that they are asking this board to essentially say, yep, all that stuff we said before, we still stick to it, and we're going to give you this waiver for the 42 feet. That's obviously oversimplifying it. That's what I view really the task is tonight. And what I would ask the board to consider is to entertain either discussion or motion on those two issues such that CM Brown, again, knows really what they're presenting to you all. The first one would be that this board is doing what the Board of Appeals said, which is reviewing the 42 foot driveway difference, and as to whether there should be a waiver granted for the 42 foot driveway. And then the second issue is that CM Brown does not need to meet the new buffering requirement because this same exact application, and I'll say one more thing on that before I'm done, sorry, has already been reviewed. One of the things that we did, because obviously for any client when they're presenting something and trying to get approval for something, is you can come back to the planning board, you can go to the court. To preserve the argument for standing, our office, on behalf of CM Brown, appealed the standing issue to the Superior Court to say that Energy North doesn't have standing to even have taken the appeal in the first place. They're not in a butter. That was the decision on that. It's not necessarily relevant tonight, but it was because they're within this 16,000 square foot commercial residential zone that kind of comes and down this way. And so under that, they just met the standard. So we've appealed that because, of course, if they don't have standing to have ever appealed, then they don't really address the substance. Energy North has filed a motion to dismiss. They filed a motion to dismiss saying this application isn't done yet, so there's no final decision. That's what they've submitted to the Superior Court. So by their own legal pleadings to the Superior Court, they've said, we're still dealing with the same thing. If we're still dealing with the same thing, MRSA 302 applies, and so the application tonight would be reviewed under the previous buffering ordinance. So that's a lot, and I apologize. So those are the two threshold issues that I would ask this board to take up in some manner, and it may be, if it's a legal opinion desired from counsel on behalf of the town, the reality is we would ask for that to be done and come back another time so that we are presenting the right information to this board. I'm happy to take any questions on any of that, but I would sort of, at this point, open you guys to have the discussion, or invite you guys, please, to have the discussion and make one of those, or both of those motions so that we know what we're presenting to you.
Has anybody taken this to legal since this came back in?
No, I received this today, and that's of no fault of their own. There's been a lot of moving parts, so they're responding to my memo. No, so this has not gone to our legal counsel yet.
No, when they brought the application back a month ago. Have we talked to legal at all?
I've talked to legal, yes, after that, but this is the first that I've heard about that the application isn't considered as a new application. So I've been treating it as a new application because the Board of Appeals sent it back here, start over from the beginning. What I believe he's saying tonight is, since the application is essentially the same, the only difference is the waiver, is that they should have some standing in the fact that they not need to meet the buffering requirement, and that we're just looking at basically the waiver, the one item that was different from the original application, the waiver request. So I have not spoken with Amy since receiving this letter today. So a couple things, let's back up a little bit. Your original approval was conditional upon MDOT permit, because remember, we didn't have that yet. Mm-hmm. We do have that now. So we did not have that. And the Archipelago had listed several items, and the Board of Appeals decided that those were all in MDOT's jurisdiction. It wasn't anything that was in our ordinance except for the driveway entrance, just the 42 feet. That 42 feet was in a standalone ordinance, which is the driveway entrance ordinance. It's not housed in site plan. And so it was an oversight on my part, and we did not pick up the 42 versus 40. that standalone driveway entrance ordinance does say that the road commissioner is the person that gets to decide whether or not it's 42 or 40 feet. But we're looking at a site plan, and we're looking at the site plan elements, and so the planning board, the question is A, whether we've got a new application, B, whether the planning board has the authority to grant a waiver for the driveway distance, or difference in 2 feet. And then the last one is, the big one is whether or not they are subject to the new ordinance language that has been adopted on November 5th, 2025 for the buffering, which goes from a Class 2, which is what was reviewed under before, to a Class 3 buffer. But I have not received a legal opinion based on what he just, I don't have it in writing, first of all, I don't have what you just said in writing, and so I didn't have anything to give to Amy to review. And so I think the big question, the line in the sand is here tonight is whether or not you would like a legal opinion on whether or not we're looking at a brand-new application, start from the beginning, or whether or not you can consider it the way that, what you've already seen, and just look at the driveway entrance width. And please correct me if I haven't summarized that correctly.
Honestly, I wish I'd have just said everything you said first and not taken as much time for everybody. So I think that really summarized it well, so thank you very much. And I'm sorry that I added so many extra words to begin with.
That was good you did. If this is the same exact plan, in my opinion, if this is the same exact plan and nothing's been changed, it's the same plan. It's been in the pipeline since last, whenever it was, May?
It started before I
Last
got
year.
here, so,
Yeah.
yeah, I think, yeah.
Mr. Chair, since this is a public hearing, do we want to ask if there's anybody in the audience that wants to say anything before we start talking about it? Or-
Did we,
I thought it was posted.
Yeah, it was posted and advertised as a public hearing, so we could hear from the other side as well.
but anyone else from the board want to have anything to
So
add?
I would open the public hearing portion of the,
Okay.
Before I sit down, does anybody have any questions for me? Because then I'll sit down and let the public speak, of course.
No, because, you haven't submitted anything, like Kathy said, in writing to her from all this stuff that you just said.
Yes.
So we don't really have anything on that, just from what you said here tonight, so.
Understood.
Not at the moment.
Okay, thank you.
Thank you. Okay, so we'll open the public hearing now, part of this, and ask anyone from the public if they have anything that they would like to add.
Good evening, Mr. Chair, ladies and gentlemen of the board, thank you for having me. My name is Michael Skolnick. I'm a land use and permitting attorney with Archipelago here tonight on behalf of Energy North. I know you folks have met in the past Keith Richard, who's a principal with Archipelago, who was before this board. I believe it was at the October 2024 meeting. And then again in front of the zoning board of appeals, or the Board of Appeals, sorry, at the January 2025 hearing. First and foremost, I do just want to address one thing, that there are remaining deficiencies in the newly submitted plan. I will go through some of the things that Attorney Dennis said, and I'm going to take them step by step. He did just say a lot. There's a lot of things that we didn't have beforehand, so I'll try and address them as they came into you. First and foremost, I do want to just preserve all comments, objections, arguments that were stated before this board or stated before the Board of Appeals in previous meetings as well, for the record, just to have those arguments expressly reserved for any potential appeal. There were 3 questions that he brought. I do have a few things I wanted to say. However, I'm going to try and build them into the thing as a response to Attorney Dennis's comments as well. First off, regarding a new application, we do think this is a new application. Was before Board of Appeals. It was reversed at the Board of Appeals and then sent back. There was a new application submitted to you with a new waiver request as well of the buffer requirements. This is not the same application that was before you in the past. There are new elements to it. If they didn't think if they didn't think this project was subject to those new buffer requirements, why would they be submitting a waiver request for them? I think they would be sitting here asking exactly what Attorney Dennis is asking you to do now, is just ignoring those elements and those new ordinance requirements. They didn't do that. They brought a new waiver request to you, and therefore it's a new application. Additionally, one of the arguments that Attorney Dennis made was that this is a pending application before the courts now. This was a Board of Appeals decision. Energy North did not appeal that decision. It was a decision that got remanded back here, so there was never a final decision. So we filed a motion to dismiss because you're legally not supposed to file a 80B appeal until you reach a final decision of the town boards. We're still in that process with the town on this application. So that's why Energy North filed a motion to dismiss that 80B appeal. Just working my way through some of these things, I did want to address the waivers. By requesting waivers at all, they're recognizing that they don't meet the ordinances with this application. The applicant asked the board to consider numerous waivers. I do want to just go through two of those major waivers, and I mentioned them already. One of them is the buffer requirements, and another one is the driveway entrance ordinance. That first waiver, and I'm going to take it at the driveway entrance ordinance first, it specifically requires a 40-foot maximum driveway entrance. Maximum. They are requesting a 42-foot entrance. That's clearly above the maximum that's allowed. I want to emphasize that this board doesn't have the authority to waive a provision of something that is not in the site plan ordinance or the subdivision review ordinance. We're clearly not under subdivision review here, but it's not a provision of the site plans ordinance that is allowed to be waived by this board. Maine's law court has specifically taken up these issues. It's addressed questions of what ordinances or review standards may be waived by planning boards. I want to just mention one specific case for you, and I just want to provide the site as well. York v. Town of Ogunquit. It's a 2001 case that is the leading and governing case for this issue. In that case, the Maine's law court, they determined that the planning board can only waive certain provisions of specific ordinances, i.e. site plan review ordinances or subdivision ordinance, development review ordinances. However, a planning board's waiver authority does not extend to zoning ordinances or other road standards or ordinances of the town that are not within those subdivision standards or the site plan review standards. A waiver of those standards would be impermissible by this board. It does not matter if that ordinance says the commissioner is allowed to waive those. The commissioner hasn't waived those. They're asking you to waive those They're asking you to waive those provisions. And this board, it does not have the authority to do that. In Maine, planning board can't grant a variance. And that's exactly what you would be doing by granting this waiver. Granting a variance. That right and that is only the right to grant a variance is only reserved by the Board of Appeals. If anything, we do agree with the recommendation of the town that receiving a legal opinion from your town's attorney would be the right way to go here. If you had any question at all about the issue, they can help you. The second waiver here is the buffer standard, the Class 3 buffer standard. You did not? No. But I did want to address it. If it was going to be a waiver, from my understanding, this board's task is to administer the town's development review ordinances and that have been adopted by the citizens of the town. Only 4 months ago, in November 2024, I believe it was, that ordinance was changed. It was amended to include this new standard. That's only 4 months ago. Your citizens said they wanted this to apply. because they wanted to address a need. Now, if it was requested as a waiver before this board, they're asking you to change that in such a short time to completely ignore the citizens of the town and what they stated as a need. Moving forward, we don't think you should move forward and allow them to have a lesser standard for a buffer between commercial and residential development. I did just want to preserve a few things too. There is substantial interest here in stormwater, and we're talking to some of the neighbors. There's substantial concerns. Due to the proximity of this project next to the Crooked River and Sebago Lake itself, it's up to this board to closely review the design and make its own independent determination. You don't have to rely, and you should not rely on the DEP's interpretation of their own ordinances. First off, in the design, the catch basins itself, they are inadequately designed. They don't comply with the DEP standards. First and foremost, there's no oil and grit separator. That is an essential point of a project, an essential design feature for any gas station, any site really that has petrol spills. Additionally, there is a sump from the drainage area in a catch basin to the bottom. The state requirement is 4 feet clearance. The ones that were presented in the design plans are actually 3 feet, so that needs to be addressed. There's also the concern of a 11-foot high vegetated slope that's relatively steep. I believe it's 1.5 feet to 1 slope, which is a substantial slope. There is an under-drain filter under it. There's absolutely no requirement for maintenance of this filter at this point. Should require them to have a maintenance plan submitted and approved by this board, or at the very least, a condition of approval that states maintenance moving forward of these drainage features. Thank you. I'd be happy to answer any questions as well. I'm sure Attorney Dennis would like to respond to some of the things I had to say as well.
Any questions? Okay. Thank you.
Briefly, I know you saw me come up here and sort of whisper to Council for Energy North, and what that was that CM Brown has not actually applied for a waiver of the buffering standard for the exact same reason that it was said, why would we do that? Because, well, we didn't do it because we don't think it applies. So that argument was made for us. We did not do that. Tom Saucier is here, and he could certainly come up here and talk about this, but if we're not getting into the substance of this application because some of the threshold legal issues, but I will just preview for you that he would submit that some of the stormwater management things you heard about depths and distances and things are not actually correct, but I don't think we need to get to that debate today and you hear everybody's opinions on that. Something that's interesting, is it just a coincidence that we were here when this board just went through the land use plan ordinance changes? If the abutter definition changes, Energy North no longer has standing, officially no longer has standing, because they will not be a abutter within this 500, foot concept. So I think that will specifically curtail their ability to have standing on this case. But that's not for you to decide tonight either. Lastly, I would just say, if it is in fact the commissioner that is to award or grant, award is not the right word, but grant the driveway permit approval, then I suppose one thing this board could do is condition on the road commissioners a permit of the driveway, or condition it on both MDOT approval and the road commissioner, because they're the two that have different levels of authority here. But we're not there yet. I just want to address some of those things for, I guess, the totality of the information of what has become much more complex now that there's a competitor that doesn't want the business competition. So I think that's all I have to say in response. Tom Saucier would probably be prepared to address much of the technicalities of this. He would not be prepared, he could probably come up with it because he's a smart guy, but the waiver requirement for the buffering the category 3, because I don't think he or I really foresaw that issue until day or two ago, and that's why you don't have anything further in writing from me on it. That's just nobody's fault at all, just a product of the timing of things. So I think I will leave it at that. And I guess I'll leave it to you to tell us if you do actually want us to move forward with the substantive application, so that Tom would take over.
I think we need legal counsel to tell us, guide us from this point on.
I have two threshold issues. The first one is whether or not this is a new application. And it is true that the waiver request did not come from them. I had listed them as other waivers that may be needed depending on where this went tonight. So whether this is a new application, if it isn't, we don't even have to talk about the buffering waiver. And the second one is whether or not the planning board has the authority to grant a waiver for the driveway entrance because it's in a standalone ordinance, not housed in site plan or in some cases subdivision, which is something that is new to me. Typically, there's specific standards for driveway widths housed right in site plan. So those are the two threshold issues that I think need to be reviewed prior to being able to move to the next step. And that will answer the next questions of what we're looking at.
If I may, to the board, to respond to that last threshold issue, which is if the legal opinion that you all receive and adopt is that this board does not have the authority to waive the driveway, we would respectfully ask that within that opinion, it is where we do go for that, so that we aren't spinning our wheels in the mud trying to figure out how to get that question
Would it be
addressed. Because obviously MDOT has looked at this a lot, and candidly, I think they prefer the 42 feet because of the size of the trucks, because of the nature of what it is, to make it actually safer. So that's one of the strange ironies here, I think.
Right.
So that we add that to the request is, where would we go?
So would the planning board be able to conditionally approve upon having the road commissioner and MDOT sign off on the driveway, basically?
Thank you, and sorry for the extra
Okay.
clarification.
So those threshold issues,
So it would be, first of all, is it a new application?
correct?
And that's an opinion that we should get from Amy,
Yes.
from legal, because it sounds like the application is still being appealed, which would kind of say that it is still an active application.
And the answer to that sets the pace for the rest of
For
the
the rest of
stuff,
it, exactly.
Yeah, and then that, exactly right. And then we might as well get the question answered of the 42 feet, and if that's something that
The review
if we
authority.
can't waive that, then how do we get that
Right.
looked at?
Right.
Do we need to
So-
make a motion to send that?
Let's see if there's any other questions first, Jeff, thanks.
So if it's a new we definitely need to know whether or not, regarding this as a new application or not. If it's a new application, to me, that's very simple how we do that, in that it's a new application, so everything's on the table again.
Yeah.
Right.
If it's not a new application, this is a question, I don't know if it's the appropriate time to ask it, but can other things be introduced? Can we ask for more information than we had before, or are we
Are
only
we just
going?
looking at the one waiver request? That's a good question. Yeah.
So I guess
The
yes,
scope
so
of the
when you
review.
ask her whether or not, or when you have
Yeah.
her review this, I personally would like to know if we could talk about noise of the trucks in a more specific, data-driven way that I don't think we did the last time. And also, darn. No, the other thing flew out of my head. But
Stormwater.
Well, anything that was brought up, if we can get a third-party review, which I don't think we did.
I believe in because I wasn't here, remember at the beginning of this one, but I looked at the application that C and Brown submitted, and it talks about Cumberland County Soils did a third
They
party.
did it,
They do,
okay.
and
They
they
did
do
do a
have an
third
in-house
party.
engineer.
Okay.
But whether or not there was more than that would be needed.
I guess I think what I'd like to know clearly from legal is if it's not regarded as a new application, how much additional things
scope?
can we ask?
Yeah, what's the scope of the review?
Sue, Jen,
I
anything?
think.
I did have go ahead.
Mr. Saucia might have had something.
Oh, I was just going to clarify that Cumberland County Soil, there's a statement that the DEP reviewed this, and actually the Cumberland County Soil and Water Conservation District reviewed it. There's a third-party reviewer. They review most, if not all, applications in Cumberland County in the Sebago Lake watershed, and they're experts at it, and their staff is experts at it, so they reviewed it very closely, believe me. So, just want to clarify that.
Thank you.
So I'd like to try to phrase this similar to how Martina went about it. There's been discussion about depths of pumps in retaining ponds. And to me, that feels a little beyond our scope. We're not engineers. That would be like us looking at a septic design, an HHE 200, and saying, where's the filter? We don't have that engineering expertise, I don't believe. And this isn't the first time this has come up. So since we're talking with legal, maybe we could find out from them what the correct response is in that situation and where those concerns are properly directed, which I'm assuming would be to either third party or to DEP. But it would be nice to have that clarification from legal, since the call's gonna be made anyway. Do you have anything?
I don't have anything to add.
All set?
Yeah, thank you.
All set? Anything else from the public? Okay, so on that note, I think that we'll table this.
Close the public hearing.
I won't,
Table
oh, I'm
it.
sorry.
Yeah.
Right, thank you. Close the public hearing, the public input, thank you very much. So we will table this item. I won't say till our next meeting. I'll say till we hear back from legal, and when what we're looking for from legal is it a new application? That'll be the first part to see if, what direction we move on and whether they would need a waiver from the Class 3 buffer if it's not a new application.
Correct.
And then
There's a list.
yeah, okay.
I get it.
You get the list? And then the other part was the road
Road
commissioner.
commissioners, who has the
giving
authority to
approval of
grant
the
a
42
waiver.
feet.
I had spoken with the applicant earlier, depending on the timing of this, it could be the next meeting, but it might be the one after that, just depending on how the back and forth responses are. Because the only thing new that you guys would be seeing would be those responses, right? So it wouldn't be like you're getting another stack of materials, so we could, not observe necessarily the submittal deadline and get them back on the next meeting potentially, depending on how long this takes.
Yep, so I didn't want to give a specific
Yeah,
date for that, so I'll just say
Yeah.
that.
Can I make one procedural question? Since you didn't make a motion to close the public hearing, could you keep the public hearing open until anything else was rescinded, until after we get the legal opinion? Just in case we have other comments.
Yeah, we'll reopen
You
it at
did
the next.
close it.
We closed it,
Yeah, I did close it after that.
But we can reopen
Reopen
it at the
it.
next meeting.
Yeah.
yes.
Okay, fine with that?
Yeah,
Okay.
absolutely, that works.
Okay, so the motion to table, to get more information
Second.
from legal, in second by Jim, all in favor? 4-5, and Jen is here, we know we saw you come in, Jen.
Thank you.
So, table to, and you are a voting member as an alternate, right?
I believe so.
Yes.
Yeah.
That was what we wanted to have happen all the time.
Perfect.
I didn't state that.
We have 6 voting.
Yep, remember, there was a discussion about that. Yeah,
If we have a full board here, then
Right.
we don't need to have the alternate.
It's fine.
Okay. So we move on to item 7, is public participation for planning board matters. Anybody have anything else to bring up? Anybody from the public? No? Okay, we move on to 8, is other business for our next meeting,
Yeah,
April 1st.
yeah, the next 2 meetings are gonna be pretty busy.
Okay.
Yeah. Yes. I'll take that back. April 1st was going to be nothing, and then the April 15th is gonna be loaded unless they come back to April 1st. We were trying to push some people into the April 1st, but we didn't get all their
Is it all
materials.
the new stuff? I mean, is it the new subdivisions we were working on? or
It's,
is it-
yeah, it's stuff that we were already working on, and then one new one.
New one,
Yeah,
Actually,
Yeah.
two.
two new ones. There's a lot of moving parts right now. One's pretty simple and the other ones are fairly complex.
Okay.
So I will let you know about the April 1st as soon as possible.
I'll make a motion to adjourn.
Okay, motion to adjourn, seconded, all in favor?